Good evening or good morning, and thank you all for joining us today. My name is Libby Swan, and I'm the Director of Government Affairs, Arts and Operations at the American Australian Association. Before we get started this evening, I wanted to give a few updates from the association. If you're an Australian looking to study in the US, our scholarship applications are now open until March 31st, so please visit our website for further information and to apply. We're especially looking forward to celebrating International Women's Day on March 8 with a fantastic In Conversation with the incredible Samantha Wills. This event, unfortunately, is at capacity right now, but you can still join the waitlist. And finally, if you're heading to South by Southwest in Austin next month, be sure to drop by Australia House on Rainey Street, where we will be hosting a full week of panel discussions, interactive displays, music showcases, and unique food, wine, and tourism experiences. We're here tonight with another immigration update. You may be aware that the H-1B visa lottery period is about to open, and that will be the focus of tonight's discussion. We're honoured to have a wonderful immigration expert here with us today, Zjantelle Cammisa Markel, to give us all the information you need to know when considering a H-1B visa. Welcome back, Zjantelle.
Hi, Libby. Thank you so much for having me back. It's been a while. I thought it would be great to do this, and thank you for inviting me this evening because it's very timely. We've been getting a lot of questions from our Australian clients right now during this period leading up to H-1B registration time, which opens March 1st and goes until March 17th. That's the period when you can register for an H-1B. And we're getting a lot of questions from our Australian clients, all clients actually, but predominantly our Australian clients who are trying to decide, should I enter the H-1B lottery? Is an H-1B right for me? Do I need an H-1B to be able to get a green card? Do I have to switch from an E3 to an H-1B? My employer's telling me I need to be in the H-1B lottery. Do I need to be in the H-1B lottery? We're getting all of these questions. So I thought it might be great to go through all the considerations and what I typically will go through with someone when they're trying to decide, should they enter the H-1B lottery or not? Or should they let their employer, I should say, register them in the H-1B lottery? So let's take it away. I'm going to share my screen. Here we go. Great. So what are we going to cover? So some of the things we're going to cover tonight is we'll talk about what is the H-1B, so that people that aren't familiar with it will know what it is. We'll talk about the differences between the H-1B and the E3, who should consider filing for the H-1B. I also want to touch on considering the L1 as an alternative, because that's been an option for a lot of our Australian clients that people sometimes forget is an option. Do you need an H-1B to pursue a green card? This is like the really hot question. Or can you transition straight from an E3 to a green card? I get a lot of questions from people saying, oh, I think I want to get an E2 or an O1 or an L because that's going to lead to a green card. So I really want to cover, do those actually lead to a green card or not? Then I wanted to cover, because a lot of the time, the reason you're going to consider applying, registering in the H-1B lottery is going to be if you're thinking of pursuing an employment-based green card. When should you consider pursuing an employment-based green card? And particularly, I want to cover that for families in the US with non-citizen children. So if anyone's listening right now and they're here on an E3 or other non-immigrant category, and they have children here with them that are dependents on their visa, so not born here, then please stick around because there's some really important stuff that I want you to listen to with respect to when you should start thinking about transitioning to a green card for your family, if a green card is something that you think your family would like to pursue. And then lastly, if you've determined, yes, I think the H-1B lottery is something I want to enter into, or my employer is going to enter me into it, just what is the process for that and the timelines and what does that currently look like? So let's start with looking at what is the H-1B visa. So our audience tonight is I'm going to guess it's predominantly Australian. Most of our Australian audience is familiar with the E3 visa, which is the visa that's only for Australian nationals, but was modelled on the H1B visa, in fact. And the similarities between the H1B and the E3 are that, firstly, the job that you're going to be doing in the US, pursuant to H1B status or E3 status, needs to be a specialty occupation. So what that means is that the job requires a degree in a specific field to be able to do it, and that the person has that degree or the equivalent of that degree through either work experience or a combination of education and work experience. Secondly, the other similarity between the E3 and the H1B is that your employer will need to file an LCA that needs to get submitted with the petition. So an LCA is required for both E3 and H1B. The LCA is the document that's filed with the Department of Labour where the employer is promising to pay the beneficiary at least the prevailing wage for that profession in the geographic region that that person's going to be working. The H1B is also similar to the E3, employer specific. So if you do get an H1B and then you change employers, you need to get a new H1B each time you change employers, just like the E3 is that way as well, Libby. So if you're changing employer on the E3, you need to get a new E3 as well. Also, similar to the E3, which a lot of people don't know, is that you can have two E3s at the same time, which is called a concurrent E3. And you can do that with H1Bs as well. You can have concurrent H1Bs. And lastly, you do need to be a W-2 employee if you're an H1B. So, and that's the same with E3s. You need to be, that means you need to be getting paid on payroll. And that goes for employers as well. So if you're an employer and you are considering whether to put someone in the H1B lottery, and they're a freelancer right now or getting paid on a 1099 and you don't want to put them on salary, then you would not be registering them in the H1B lottery. And just on that note, Libby, I just wanted to point out that tonight I'm going to look at this from the perspective of the beneficiary. So the person that's going to be getting the H1B or deciding whether they should switch from E3, or their other non-immigrant status to H1B and getting a green card, rather than from the perspective of the employer, just because that's where most of our questions have been coming from. And I think that that's where most of our audience sits tonight. So I just wanted to, but I'm just putting in there for the employers, just so that they don't feel like they're left out. But the information, and if you are an employer that's listening, the information that we're going to learn tonight is relevant in making the decision as to whether you're going to register your employee in the H1B lottery anyway. So just
I'm glad you brought that up, Zjantelle, because I have seen a lot of questions about employers trying to pressure their employees to move to a H1B for various reasons. So it's good to have this information tonight so we can dive into what those considerations may be.
That's good that you bring that up, Libby, because we've seen, a lot of our clients come to us and say, my employer is going to put me into the H1B lottery. Should I be being put into that lottery? What we see is, like with the larger companies, often what happens during H1B registration time, it's really tough for those companies, the HR departments and or their immigration counsel, to really go through each individual that might need an H1B and determine specifically for that individual whether they should or shouldn't be entered into the lottery. So what they'll do is just do a sweeping, let's put everyone in the lottery and then determine later what we're going to do, whether we should put them in or not. But if your employer said that to you and you're not sure, maybe after tonight you'll have a bit more clarity as to whether being registered in the H1B lottery is good for you or not. But if you really feel like, oh, you know what, I don't think I should be registered, then it's worthwhile saying that to your employer, because as we know, it's a lottery. And if you're going in it and you're definitely not going to ever use that H1B and you get selected, you're taking a number away from someone that really does need an H1B. So that's really good that you brought that up. Thanks, Libby.
No problem.
Okay, so we went through the similarities. What are the differences between the E3 visa and the H1B? So The E3 you can apply for directly at the US consulate abroad and then get the visa stamp put on your passport and you enter. You don't have to do an I-129 petition with USCIS first. With an H-1B, you absolutely must file an I-129 petition with the USCIS, which is filed by your employer. So as a result, this also takes a bit longer to get an H-1B and more costly too because of the filing fees with USCIS. There's a cap for the cap between the E3s and the H-1Bs is different. The cap for the E3s is 10,500. We have not met that each year. So we can, that means that Australians can apply for an E3 at any time in the year because they're always available. Unlike the H-1B, which has a cap of 65,000 each year with an additional 20,000 reserved for people that have a master's or higher degree from a US university. So basically 85,000. There is also a carve out for Singaporeans and Chileans there. There's 68,000 of those carved out for Singaporeans and Chileans to have their own. So Singaporeans and Chileans, if you are Singaporean or Chilean, you don't necessarily have to go into the lottery because those don't meet their cap. And theirs is similar to the E3, which is interesting. I'm sure a lot of the viewers didn't know that. But coming back to the regular H-1Bs, because there's only 65,000 of them, or 85 if you consider the master's cap, and there's about 500,000 people that apply for them each year or register, it's a lottery. And so they're gone each year. So if you don't enter the lottery between March 1st to March 17th, or you don't get selected in that lottery to then file an H-1B, then your next opportunity to enter the H-1B lottery is not until March next year with an October 1 start date of next year. So that being said, the difference between the E3 and H-1B also is that the earliest start date in H-1B status, even if you get picked in this lottery in March, is not until October 1. So that's something that people will need to be mindful of. The H-1B only has a 6-year maximum validity period. The E3 is valid indefinitely. With that 6-year validity for H-1Bs, that can be extended beyond 6 years, but only if the green card has been commenced before the person has entered into their 6th year of H-1B status. So if you are going to switch into H-1B status, you want to, because you're going to be pursuing the green card, you want to make sure that your employer is on board with sponsoring that green card pretty soon into the process of when you're on that H-1B. This one's a big one. So H4, if you switch into H-1B status, your dependent spouse as an H4 spouse does not get work authorization. There is a small caveat to that, which is that H4 spouses do get work authorization, but only at a certain point of when the green card process has been started. And that to get to that point requires at least a year and a half to get to that point before the H4 spouse could apply for work authorization. So if your spouse needs to switch to H4 dependent status and they need to work, this could be problematic. And we're going to cover that. We're going to look at that in a moment. If you have ownership interest in your employing entity, that can be problematic for the H-1B as well, because with the I-129 petition filing, you need to disclose any ownership interest in the entity. And immigrant, so the big reason why most people apply for an H-1B is because if they are Australian, this is like lots of non-Australians have to apply for an H-1B because it's the only option that they have. They don't have access to the E3. But if you do have access to the E3, then typically you're applying for the H-1B because it has immigrant intent, whereas the E3 doesn't have immigrant intent. And so because the H-1B has immigrant intent, you can openly and actively pursue a green card while in H-1B status. That doesn't mean that you can't pursue a green card in E3 status. So, and we will cover that. And that's really important for people to know. The benefit, though, of being able to have immigrant intent in H-1B status is that you're able to travel internationally at any point in the green card process if you're on an H-1B. Whereas if you're on an E3 and you're pursuing a green card, there will be a period when you get to a point in the green card process, which is called adjustment of status. When you file that adjustment of status, you will have a period where you cannot travel internationally until you receive what's called a travel document or an advance parole document. And right now, those documents are taking about 8 months from when you file for one to receive. So you would be stuck in the US for about 8 months if you're going right now, if you're going from an E3 to a green card. So some people are like, you know what, my employment won't allow me to do that. I need to be traveling frequently, internationally. And so therefore, those people, an H-1B is a good consideration. We know with COVID, people have learned to do their jobs without international travel, but as the world has opened up again, I think people are really loving that ability to do business again in person and traveling. And so this is something that people should consider if it's part of their jobs, especially. Okay, so let's go to the next slide. So I thought I'll deal with this first, which is the majority of the questions were coming from people that are in E3 status and thinking, should they switch to an H-1B? So pretty much where we land every time that I talk to someone that's in this situation is the following as to who should apply for an H-1B. Those who are in E3 status wish to pursue and want to pursue a green card and need to travel internationally frequently for their job or for personal reasons or whatever it is, and really don't want to have that period where they can't travel. So those people. And another category that really need to think about the H-1B is if you were born in India or China. So you can be an Australian citizen and on an E3, but if you're born in India and China, the green card process and certain bit timing as to when you can file certain parts of that green card process is based on the country where you were born. So I'm going to explain this. If you are an Indian national, well, not an Indian national, you could be an Australian national as well, but if you were born in India and you're pursuing a green card, then the most common green card categories are what's here, the second and third, which are known as EB2 and EB3. EB2 is for jobs that require a master's or higher degree, and the person has that. And EB3 is for a bachelor's and anyone else. EB1 is multinational managers and executives or extraordinary ability aliens. But most people fall within EB2 and EB3. So if you look here and you come across this is Chinese nationals, but if you look at Indian nationals, it's showing this chart, it's called the Visa Bulletin. And this is the Visa Bulletin for March, if anyone's interested in which one it is. And it's showing that the people that anyone born in India can now start the last phase of their green card process, which is the adjustment of status, if their green card process started on or before August 2012. So that's showing us it's taking someone who's born in India 11 years to get to that last step in their green card process, even if they're an Australian citizen. So those people, because that's taking a long time, there'll be a long period between filing their I-140 part of their green card process and the filing of their adjustment of status part of their green card process, which are steps 2 and 3. And it will be tough for those people to renew an E3 continuously for years in that period. Most everybody else who is born in Australia and is Australian fall here. You'll see in the green there, I highlighted it in green, is C. C means current, and that means you can file your adjustment of status at the same time that you file your I-140 part of the green card. And the green card process right now for someone who's born in Australia is taking about 2 years, 2 to 2.5, depending on certain variables. But what that means is that you can, as an Australian, you can transition from an E3 to a green card potentially without having to renew your E3, or if you do need to renew your E3, it might only be once, and you could do it at a time during the green card process where you have not yet expressed immigrant intent, because it takes, from when you start that green card process, it takes about a year till you get to filing the I-140 part. And in that first period, it's really employer driven. And so you haven't expressed immigrant intent yet. So if you needed to renew your E3 during that period, you could. So that's how and why right now, because the visa bulletin is really favorable for Australians, you can most certainly go from an E3 to a green card without requiring an H1B first. So if you're an Indian national, I just wanted to make this clear too, if you're not Indian national, but born in India or China, if you have a spouse that's born elsewhere, you can actually claim your spouse's nationality for the green card process. So if that is you, definitely talk to your immigration attorney about that. Also, if you're an Indian national and you can fit in EB1, which is right here, you'll see that's 2022, so it has less of a backlog, then maybe you won't need to switch to an H1B because the green card process is faster. So you could go from E3 to EB1 green card as an Indian national without requiring an H1B first. And EB1 is for multinational managers and executives, and we're going to come to that, or extraordinary ability aliens. So people that have won awards, have press about them, are basically famous at what they do in their area of what they do. Okay. So what do people that are on an E3 that want to transition to an H1B because they want to get a green card need to be mindful of? So these are the things that I look at when an E3 says to me, should I register for the H1B lottery? First thing I look at is, do you have a spouse that is here as an E3D and has an EAD attached to that, or is working, pursuant to their E3S status? And how's this going to affect them? So first thing I look at is that spouse also Australian? Because could we, if you pursue an H1B, could we just put them on their own E3 so that then they can keep working? Because as an H4 spouse, we know they're not going to be able to work. So if they're and if they are Australian, can they actually get their own E3? What's their profession? So for example, we had a client last week whose wife is an actress, and that doesn't work for her own E3. And she's not quite O1 at this point. So for them, him getting the primary spouse getting an H1B would be catastrophic for the wife, who really needs that E3S to be able to work in her field. So even if your spouse is Australian, double check what's their profession. Do they need the ability to freelance? And would an E3 not actually be ideal? And if they're not Australian, an E3 is not even an option. So we need to look at other opportunities, which might be an O1. Are they going to register themselves for the H1B lottery? But now that's a lottery, right? So one gets picked, and then, that's just not so great. That's not so ideal. So if you've got a spouse, you absolutely want to think twice before you start switching to an H1B, because it could really affect your spouse. Okay. Again, time limit, we kind of touched on this earlier. You've only got 6 years if you switch into the H1B in H1B status. So just be sure that when your employer is putting you in the H1B lottery, it means that they're actually also committed to starting that green card process for you. Because if they don't start it in time and you run out of H1B time, you're switching back to an E3, most likely at the end of that. So then that was all a waste of time. Again, remember that the earliest start date in H1B is October 1st. So if you get selected in this round of H1B lottery and your H1B gets approved, earliest start date, October 1st. So what status are you currently in? When does that expire? Are you going to have a gap? Do we need to deal with that gap? So just think about things like that. The H1B, if you do get selected and approved, remember you still need to get that H1B stamp put in your passport next time you travel internationally. And so will your family members that are going on H4 status. They'll need to get that stamp put in their passport too. And make sure that if your employer is putting you in the H1B lottery and you do have dependents, any kind of dependents, a spouse and or children, that you do make sure that the immigration attorney is aware of that, because if your case is filed as a change of status, you want to make sure that 539 change of statuses, if the spouse and children need to change to H4 status, are filed for them too. We see often where spouses and dependents have been forgotten, and then they're in this like no man's land and like out of status because primary spouse changed to H4 and the dependents didn't change yet. So we just want to avoid that. And then lastly, just double check that your profession, is amenable to an H1B, right? Which is similar to in previous webinars we've talked about. If you're going to try and get an E3 through an I-129 filing, it's the same kind of considerations here. What's the size of the employer? How many employees does it have? What were the revenues of the company last year? Who owns the company? All of these considerations are more important when you're filing an I-129 because you have to disclose all those things on the form.
Zjantelle, we had a question come through then. If you are moving to a H1B and you have a spouse that's staying on their own E3, does immigrant intent come in when the E3 renewal is happening? Will the immigrant intent of their spouse on a H1B come into consideration?
So that's a really good question. It depends at what point in the green card process the couple is. So typically it won't, because when you go and renew your E3, it means you haven't filed adjustment of status yet. So you outwardly have not displayed any immigrant intent. On your DS-160, you do need to list your relatives in the US, so you will be listing your spouse and what status they're in. So you'll be listing that they're in H1B status. So where that would come up is that maybe the immigration officer might say, oh, you've got a spouse in H1B status. You know, why are they in H1B status? Oh, their employer put them in H1B status and that's why, right? You don't have to then necessarily say that they're in the green card process unless they've gotten a green card. But if they've gotten a green card, you will have gotten yours too by then. So I think that that's fine. I think that an E3 spouse that needs to renew their E3 with another spouse that's in H1B status is not going to be problematic.
Okay, great. Good to know. Thanks.
Yeah. You know, and strategically though, just because you're bringing it up now, and I know that someone asked a question about this actually. What was their question was something about like how would it work? You know, should someone, if one spouse does go on an H1B and the other one stays on an E3, or has the ability to switch to H4, when should that spouse switch to H4? There was that question. So
yeah.
Person, so they'll be, hopefully they're listening. So strategically, when the E3 spouse could switch to H4 would be just before filing the adjustment of status, because that's when the E3 spouse won't be able to travel internationally, whereas the H1B spouse will be able to continue to travel internationally without any issues, right? Once the adjustment of status is filed. Whereas the E3 spouse, if they don't change to H4, have to wait for their travel document that comes with the filing of the adjustment of status before they can travel internationally. So if that couple want to travel together internationally, that's when the E3 spouse might consider switching to the H4 status.
Okay.
But it gets a bit complicated. This is where you really need to speak to an immigration lawyer, because that person then wants to consider their work authorization. But maybe their work authorization documents already come through because that came through before the travel document, and they're fine because they have their EAD. So then they can now travel on H4, but they have their EAD from their adjustment of status. You know, in any event, definitely talk to an immigration lawyer if you're in that situation. So I wanted to cover another category, the other most popular category of people that ask, you know, should I be entering the H1B lottery, and or should I be pursuing an H1B or an E3, are the people that are on F1 status after they've finished their university studies, and they're usually in OPT status for 1 year or 3 years if they qualify as a STEM, to have STEM OPT. So if you're not Australian, then yes, you should be entering the H1B lottery most likely. But if you are Australian and then the E3 is an option, more often than not, the E3 will most likely be the more attractive option. I try to tell people to also, by the way, stay on F1 and OPT status as long as they can, because it has tax benefits. You don't have to pay the FICA and Social Security taxes, so you get a little bit of tax saving. So I try not to rush our clients off of OPT to E3 or H1B. But if your OPT ends before April 1st, then your gap in between your OPT ending and your H1B starting, if you were to file for an H1B, would not be bridged. And so therefore you would need an E3 anyway. So look at the date that your OPT ends. That's important in deciding this. And other considerations like, we have a lot of students in technology that then are co-founders of the company that then they want to then work for. So that wouldn't be ideal for an H1B. So look at things like that, talk to your immigration lawyer, obviously. But if you're the ones that are Australian that would necessarily enter the H1B lottery already are the ones that know they want a green card, know they need to be able to travel internationally, and or are born in India and China and want to get started on that green card process right away. Okay, what about J1? What if you're in J1 status? What do you do? Do you apply for an H1B? If you're not Australian, yes. But you might not be able to. So first of all, the first thing you need to check with anyone that's on a J1 is, are they subject to the 2-year home residence rule? If they're subject to the 2-year home residence rule, H1B is not even an option, because you need to get a waiver of that home residence rule before you can even get an H1B. So that's easy. The good thing to know is, though, if you are subject to the 2-year home residence rule, you can transition to an E3 or an O1 without having to get that 2-year rule waived. So Australians are very, very fortunate in that respect, that if they've been on a J1, they've got the E3, hopefully, to be able to transition to after the J1, because often the H1B is not even an option. Okay, what about O1 to H1B? O1s generally are people in the art. A lot of the time are people in the arts. And so if you're in an arts-based position, you're a makeup artist, you're a stylist, you're an actor, those jobs are not really specialty occupations anyway. So most likely you wouldn't qualify to submit an H1B. The only people that might consider going from O1 to H1B is if you're on an O1A, which is in the business category of O1. And so therefore you would qualify for an H1B, and you're pursuing a green card, and you need to travel, not have that interruption in ability to travel internationally. Those are the people that might consider O1 to H1B before a green card. Okay, so I wanted to bring this up. This is the L1 as an alternative, and only because I think more and more Aussies are coming here on the E3, but also qualified for the L1 at the time that they came, but ended up on an E3 instead of the L1 because the E3 was faster, cheaper, and did the job just as good as an L1. So let's come over on the faster, cheaper option, right? So now those people that would have also qualified for an L1 should actually look at that as their alternative to an H1B, where the benefit is just that ability to travel when they're trying to pursue the green card, because the L1 also has immigrant intent. So if you switch back to if you switch to an L1 and you pursue the green card off of the L1, then you can travel seamlessly internationally that whole time. Also, if you qualify for an L1A, which is a manager executive L1, then that lends quite nicely to the EB1 manager executive green card category, which is a great green card category because it's a little bit faster, also because the employer won't have to advertise your role. So that is definitely something for people to look for, and particularly if you're born in India and China, definitely look at that as an option as well.
Do you have to switch to the L1 to get an EB1 multinational green card, or are there other avenues?
That is an amazing question, Libby. You don't. You can go straight from E3 to EB1 green card, multinational manager executive, and we've done that multiple times before, mainly just because we just didn't want to pay the fees twice. Why? If you can qualify for the EB1 green card as a multinational manager executive and timing is going to work to go from E3 to green card and you don't have those international travel issues, you can jump straight to that and invest the money that you would have spent on that L1 straight into the green card. That's a great question.
Excellent. And what about if you have, like you said, some people come on an E3 just because it's easier when they could have come on an L1. Can you, if that's your situation, can you then go back to an L1, or does being on an E3 kind of wipe that as an option?
That's an excellent question as well. So it is an option, but it's only an option if you have not worked for another employer in between. So when you're to qualify for an L1, the company that you work for in the US has to have a corporate relationship with the company you worked for abroad. You have to have worked for it for at least 1 full year abroad, and then you've come over to the US. As long as your employment in E3 status or J1, E3, whatever you do before switching back to the L is only with that related company, then you can go back to an L1. If you've worked somewhere else in between that's not a related company, then you cannot go back to an L1. So that's an excellent, excellent question. Thank you.
Great. Thanks, Zjantelle.
Okay, so do you need an H1B to pursue a green card? I feel like I kind of already answered this. So the short answer is no, but it might be a good idea if you need to travel internationally frequently, or you're born in India or China and EB1 or EB5, green card categories are not immediately available to you. So can you go, which another way of phrasing it, how many ways can we put this, is can you transition straight from the E3 to the green card? And I feel like we did cover that too. Yes, the answer is it's possible, but you just want to be looking at the visa bulletin, seeing the timeline and making sure that the timeline will work from going from the E3 to the green card in the stages that you need to be able to file that adjustment status and be considerate of, will you need to travel internationally or not? Pardon me.
That's okay. Zjantelle, there's a few questions coming through, so I just want to clarify. When you're talking about an E3, you just have to hold an Australian passport. They're just looking that you're an Australian citizen. But when we're talking about applying for a green card, they're actually looking at your place of birth. So having an Australian passport, if you were born in, certain other countries, doesn't really mean anything. Is that correct? For a green card, it's where you were born.
Correct. So for the green card, so that's true also for the diversity visa lottery, by the way, the green card lottery. If you have an Australian passport, doesn't mean you can necessarily enter the green card lottery or go straight from E3 to green card pursuant to the all chargeability areas for the visa bulletin, because it's based on your place of birth. Yeah,
fantastic. That's what I thought, but I'm just seeing
that being said, also for the visa lottery, sorry, I'm like choking here, if you have a spouse that is born in another country, you could use what's called cross chargeability and use your spouse's nationality to get to the green card faster. That's when you want to just definitely get an immigration lawyer involved, because that's a whole nother webinar.
Yeah, well, that's a good reminder for everybody that, this is helpful information, but everyone's circumstances are different. So you should always get some professional advice, to make sure it adheres to what your personal circumstances are.
Definitely. And even though we're going through all of this tonight, you can kind of make ideas as to what of this applies to you, but certainly get your own particular and personal advice from an immigration attorney for your own situation, for sure. Okay, so this is this question that I always get. I think the thing that frustrates Australians on E3s the most is the fact that you have to renew it every 2 years. So I get a lot, I just want something more permanent. I don't know if I want a green card, but I'm tired of having to go every 2 years and renew the E3, and I have to go travel to these wonderful places to go get it. It's such a pain. But in any event, so they're like, oh, what about, should I consider an E2 or an O1 or an L? Because I think these, doesn't an O1 lead to a green card? I'm going to get an O1 because it leads to a green card. Or I'm going to get an E2 because it leads to a green card. So I wanted to sort of demystify that and clarify that there's no visa that leads to a green card, right? So the green card process is a process that stands on its own always. So you have to go through the green card process. And whichever green card, you pick to go through, you go through the steps of that green card, and no non-immigrant underlying status is going to help towards that. And in fact, here with the E2s, because if you're the investor and owner of the business, sometimes that can be an impediment to a green card, unless you're pursuing potentially an EB5 investor green card. Where it can be sort of helpful, it doesn't lead to a green card, but can be helpful in the O1 context is there are two types of O1. There's O1A, which is for business, and there's O1B for arts, which sounds odd because you would think O1A is for arts and O1B is for business, but it's the other way around. If it's O1A for business, the criteria for that O1 are very similar to the EB1 green card. So if you've been approved for an O1A, then it's very likely you would get approved for an EB1 green card. So that's where, it's an indicator that you are good for a green card in that category. If you're O1, be cautious though, if you're O1B in the arts, the criteria for that are very different to O1 to the EB1. And you might, just because you have an O1B doesn't mean you'll qualify for EB1. So that's definitely, you want to talk to your immigration lawyer to go through all the criteria of the EB1 to see if you qualify. Similarly, the L1A, while it's being on the L1 doesn't get you to a green card, but it's a good indicator. If you get approved for an L1A as a multinational manager executive, it's a good indicator that you will most likely get approved for an EB1 multinational manager executive green card. So it's like a let's see, yeah, I got approved for that, so I'll probably get approved for the green card in that category. So that's good. And the last question I always ask our clients when we're in a consultation and they haven't, we typically ask a whole bunch of questions before they come to us, or we know them and we've known them for a while. But if we know, if nothing's been indicated that they have a spouse, I often always ask, are you in a relationship? And then they're like, why she asked me this? Geez, this lady's nosy. I'm not really just trying to be nosy. I do love to get to know our clients, but I'm asking it also because sometimes people are like, oh yeah, I want an H1B and I'm going to pursue a green card and I'm going to go down this track and then I'm going to get an O1 so that then I can do this. And we go through all this convoluted stuff. And then, oh, by the way, yeah, I'm dating an American citizen and we are engaged. We're going to get married in 2 months. So, if you're in a relationship with an American citizen or a permanent resident, or even someone else who's not in a non-immigrant visa category, but they're pursuing the green card, you could get to a green card much faster through your relationship than maybe even these avenues. Also,
what is the processing time right now for a marriage-based green card?
Oh, marriage-based green card is about a year right now.
Okay. So it's pretty fast when we're looking at some of these other times.
Yeah, it's much faster. And also, if you're dating with someone who's like on an L or an H1B or an E3 and their employer has gone down the green card track for them, if you get married before the person gets the green card, then you're getting a green card with them. So you could just kind of jump on the back of that and take advantage of it. It just doesn't sound right the way I'm saying it, but
the timing just may work.
Married to the person, yes, as long as it's someone you want to marry, then think about timing as well in that, because it could make a big difference.
Yeah, fantastic.
Okay, so when should you start considering pursuing an employment-based green card? Since most of the people listening want an H1B, and whether they should enter the H1B is because they really want to pursue a green card. When should you start? Think about it. You can think about it anytime. And since we know now you don't need an H1B to pursue the green card, you can pursue it at any time. You don't even have to have ever had a visa to start pursuing the green card. You can actually pursue a green card from outside the US. It just takes about 2 years. And so, if you want to be here before 2 years, then you would need a non-immigrant visa to be here and work here on. So a lot of people don't go straight to green card unless they know they've planned so far ahead and they're like, oh yeah, I want to be in the US in 2 years. So I'll start the green card process now. So most people do come here on non-immigrant visa first. But so so the other people that can start anytime is that you've gone through the process of deciding you want to be permanent, you want to make the US your permanent residence. And I often advise clients, particularly if you have assets, international assets abroad, to definitely speak with a tax advisor and or accountant before making the decision to get a green card, because there are certain tax implications that come with being a green card holder. We're not going to cover tonight the pros and cons of getting a green card and not getting a green card and all that, because that's a whole nother webinar. Maybe we'll do that, coming up. But just definitely one of the things to consider is definitely tax issues, if as to whether you should be exploring a green card or not. And if tax issues leads to you shouldn't be getting a green card, then, and you've got other options other than an H1B, then probably you're not going to enter the H1B lottery. Don't take that number away from someone else. Yes, and then just, do you have any other avenues towards a green? If you do want a green card, are there any other avenues towards a green card, such as diverse, family-based green card, which we just spoke about, for marriage, or diversity visa lottery as well, is an option as well. You can enter the visa lottery. If you're a married couple and you both enter the visa lottery, you double your chances, because it only takes one to win and both get it. So that's good. Okay. So this one's a really important one for anyone with non-US citizen children in the US with them. I really want to cover this because I think it's really, really important. So if you're here and you have kids that are here as dependents on your visa, and it doesn't matter if that's E3 or L or O or whatever the dependent status is, those people absolutely should start thinking about whether their family would like to get a green card ever. And if they think that they would, the time to really think about this and start making a decision is when the oldest child is around 15 years of age. And I'm going to explain why I pick that age. This is not in any rules, by the way. This is just my opinion. This is just what I see and think, right? Like there's not in any books. It's because, so first of all, the first thing is that your child can no longer be on a dependent visa of yours at the point that they hit 21. So at 21, they have to get onto their own visa. And often, what we see more often than not is, this is if you haven't got a green card yet for the family. So as well. So then that kid is usually transitioning to an F1 as a foreign student visa, because that's usually really all they're going to qualify for. Even if they're Australian, they're not going to qualify for an E3 until they've got a degree, and they usually don't have a degree by the age of 21, right? So the F1, so they're pretty much forced to go to college, or potentially leave. And where this becomes really important is also if your family is not in the green card process and has not filed adjustment of status part of the green card process before your oldest child has turned 21, then that child is going to miss out on getting a green card with the rest of the family. And most people are, all right, that's fine. We'll just catch them up later, But it actually gets really complex for that kid. So what happens is, once you get a green card as a parent, you say, okay, I'm going to sponsor my 21-year-old child now for a green card. But that's actually taking about 7 years. And then that kid, if they want to stay in the US, has to try and find a way to stay in the US during that period. So they'll be here on an F, and then they're going to try and get an E3. But now they've got a family-based green card petition that's been filed for them, and it's going to make it tough for them to even get the E3. So it can make it really hard. And what's worse is if they get married, then it makes it even next to impossible, because as a green card holder, you can't even sponsor a married son or daughter who's over the age of 21. You have to become a citizen first. So, and you have to have a green card for 5 years before you can become a citizen, and then add on the number of years it takes to then sponsor that kid. So as you can see, it becomes quite disastrous for a child who ages out, is what it's called. So 21 is like the age there, right? So yeah, you could say, let's start this, it takes 2 years, let's start it when the kid's 18. Why do I need to think about it when the kid's 15? The reason I go back to even 15 is because the other question I get from a lot of our clients is, hey, my kid Libby is 17 and she wants to get a part-time job. Can she get a part-time job on her E3D? No. Can she get a social security number? No, she can't work. So the only way your dependent children on any non-immigrant dependent visa can work is if they have a green card or an EAD, you know, through pretty much pursuing a green card through marriage or something else. So this is why I always look back at about 15, because you go through the green card process. It takes about 2 years. So then hopefully your family are getting green cards by the time your eldest child's about 17. So if they do want to get any part-time jobs, they'll be able to. Also for college applications, it's a lot cheaper for families to send their kids to these colleges if they have a green card than if their child is still in a non-immigrant status or on an F1 at this point, which they'd have to switch to and then pay foreign student fees, which is a whole nother thing in and of its own.
Yeah, that's great advice. I mean, especially avoiding the international student fees, because they're no joke in the US.
Yeah, it's so true. I actually put this chart. This is the visa bulletin again. That sort of shows just the timing, right? So unmarried sons and daughters of US citizens, even if you become a US citizen and sponsor your child that's over the age of 21, it's taking like 7 years, right? Spouses and children, that's spouses and children under the age of 21, current. That means, yes, they're going to get the green card with you. Unmarried sons and daughters over the age of 21. This is what I was talking about. So your kid hits 21, they're not married, and now you've got a green card, but you want to sponsor them. It's taking, so they can't file their adjustment of status until unless you started the process in 2017 right now. So it's showing it's like 6 years right there. And then married sons and daughters, there isn't even a category for permanent residents because you have to be a citizen to sponsor your married son or daughter. And as you see here, that's taking like, oh my God, I don't know. How many years is that? 14 years. Yeah, it's a long time. Brothers and sisters, I thought this was just interesting because some people will say, oh, my brother's a US citizen, can you sponsor me for a green card? Often that's not a great idea because that's taking, oh my God, my math. How many?
16 years.
16 years. And so if the person's here, they have to be in a non-immigrant status for 16 years until they get the green card. So if you're Australian and on your E3 and you have a brother that filed an immigrant petition for you or sister, that's not going to be good for when you're renewing your E3 each time to have a family-based immigrant petition in the background. I mean, you could try and argue, I don't have immigrant intent, they filed that, blah, 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 but still it's not ideal.
Yeah.
So you're better off pursuing a green card through employment or marriage or other avenues than through your brother or sister. Okay, so what happens? You decided through all of this, yes, actually, I'm one of the few that absolutely needs an H-1B. And so I need to enter the lottery. What does that mean? What do I do? So first of all, you can't enter it yourself. It has to be your employer. Only the employer can become a registrant and register someone for the H-1B lottery. Employers can only put in one registration per beneficiary. That means, Libby, so for example, the AAA could only put in one registration for you for one role. They couldn't put in multiple H-1B registrations for you for multiple roles there to try and increase your chances. But AAA could put in a registration for you. Ms. Markel put in a registration for you. Bluestone Lane, I'm sure they want you. They could put in a registration for you for the H-1B. So a beneficiary could have more than one H-1B petition or registration filed for them, but it must be from different employers. So if you have multiple by the one employer, you'll be disqualified completely. So that's important to know.
So then going to, I get selected and I'm off to work at Bluestone Lane. You have to follow through and go and work for that employer, or?
If you file it as a straight petition and not change, if you file it as a change of status, then you're going to automatically switch on October 1 from your E3 to H-1B with Bluestone Lane. So you'd have to start working for them.
Yeah.
if you wanted to get off it, you'd have to like file another petition to get off it, or go get another E3 to get off it. So in that instance, if you weren't sure if you want to start working for Bluestone Lane, you said to me, you know what, I don't know, I can't pick between AAA and Cammisa Markel or Bluestone Lane. What am I going to do? They're all putting H1Bs in for me. Then they would each file it what's called straight, not as a change status. And then if they all got approved, then you got your pick of the lot as to which one, if you ever wanted to activate it in 3 years, the H1B is valid for 3 years, you could then activate it any point. So you could stay on your E3 even for a little bit and then use the H1B a bit later, which strategically might be smart if you then later, one of those employees says, you know what, Libby, I'm going to get you the green card. I want you so bad. I'm going to sponsor you for a green card. And we've got this H1B sitting here. So come on over. You might say, okay, great.
That's great. I know there's some Bluestone Lane staff members on the webinar tonight. I can see them here. So shout out to everyone from Bluestone Lane.
Because hopefully wouldn't mind me, mentioning their names.
Yeah, just an example.
Just as an example, exactly.
Fantastic.
Okay, what else? So the registration, if you're going to enter the lottery, your employer must register they can set up their account right now as of yesterday, although yesterday it wasn't working, but as of today it is. So they can actually set up their registrant account with USCIS already from now, but they can't actually put you in as a registrant until March 1st at noon. And then it closes noon on March 17th. I do not recommend people to wait until March 17th. And this is why we're doing the webinar now, so that people have time to decide. So that then, and hopefully in that first week of March, if you are entering it, you've convinced your employer that it's good to enter you, and they're doing it and they're registering you. Get them in touch with an immigration attorney if they don't already have one. So once that closes March 17th, and then USCIS runs their lottery. And if you have a US master's or higher degree from a US university, you actually have 2 chances. You have a higher chance of getting selected in the lottery. So that's kind of good. Once they've finished running the lottery process, which they'll do by March 31st, then as of April 1st, they will start to notify the employer and the attorney representative as to whether their person has been selected. And then employers have the ability at that point between April 1st to June 30th of filing, if you've selected, of filing the H1B petition. And you have to file it by June 30th. So if you get selected in that H1B lottery and you don't file that petition by June 30th and July 4th comes around and you've been on holiday, come back from July 4th weekend, my H1B, well, you're bad luck now. You have to reapply next March and you've lost that whole lottery win, basically. And then as a reminder, you have to file by June 30th. Those petitions will then get adjudicated, but the earliest start date that you would enter into H1B status would be October 1st of 2023. So that's the timeline and process. This is just a quick sort of synopsis of those key dates right there. And that's pretty much it.
So, Zjantelle, I know we're almost out of time, so I won't ask too many follow-up questions, but say I've been listening tonight and I've decided, you know what, H1B doesn't seem like it's for me, green card's not for me. How long can I stay on my E3 for? Is there a limit?
It's a really great question, because I do get a lot of clients that keep saying to me, but I can't stay on an E3 forever. I have had clients on an E3 for 18 years from when it first came out in 2005 who have not had any issues and problems renewing their E3 because they genuinely don't have immigrant intent. So as long as you don't have immigrant intent and you don't display immigrant intent when you go to renew your E3, and you genuinely are like, you know what, I'm doing another 2 years, don't want a green card, don't have plans for a green card, don't have plans to live permanently in the US, then you certainly can. And that's what that's why it says it's renewable indefinitely. Indefinitely means for as long as you like, and we're certainly seeing that.
Yeah, that's good to know. What are the considerations for transitioning from an E3 visa to a family-sponsored green card? I know you went through this a little bit, but what are those key things people should be looking into?
That's a good question. So typically, if you're on an E3 and going to, you're getting married to a US citizen or a permanent resident, green card holder, and you're going to get the green card that way, the key things that this could be much longer, so I'm going to give you just a shortened version. But the first thing I look at is when you have to be married, right? And then we're going to file for the green card. When you file for the green card, and if you're doing it via adjustment of status in the US, you are also, at the point that you file for adjustment of status, you're going to be applying for a work authorization document and a travel document at the same time. And the work authorization documents are currently taking 3 to 6 months. Travel documents a little bit longer. But what's more important, like you will have already established with the person, like, hey, by the way, if you're going from E3 to green card, when we file it, you're not going to be able to travel internationally. So they need to think about when they're going to file for that green card as to a period where it's good that they don't have any international travel coming up and can be here in the US for a good chunk of time. If it results in that the travel document takes that amount of time, there is a way to get an emergency travel document if there is an emergency in that process. But the other key one is the EAD. If their E3 is going to expire and they're working for an employer, but their E3 might expire before they're going to get that EAD through the green card process, then we might want to still renew the E3 before they file for that green card process. And just point out, just be cautious of any gaps of employment. Also, if you're thinking you might change employer, that's an important consideration before you apply for an employment-based green card, family-based green card too, because once you've filed the adjustment of status, you're no longer in E3. So you can't just go get another E3 with another employer to start working for another employer. You would specifically have to wait for your employment authorization document to come through to start working for that new employer. So if you're not happy where you're currently working, that's something you want to talk through with your immigration attorney with respect to timing of filing that green card case. That is such a good question.
Oh, thank you, Zjantelle. As always, it's been a pleasure, and I know we're out of time. It's always so much to fit in, but we can have another webinar with you in the near future for further immigration updates. For everyone who did join us today, if you registered, you'll receive the replay of this video along with the slides via email, and they'll also be posted on our website. While you're at the website, you can also support the American Australian Association so we can continue with programs just like this by signing up to become an individual member or making a fully tax-deductible donation. So thank you for joining us, and we'll see you next time. Thanks, Zjantelle.